ACV18-0594, FST Farms versus Vanderwey. Each side will have 20 minutes to present their argument. Appellant, you may save any portion of that for rebuttal, but you'll have to keep track of your own time. That's why we have like the podium for you. We we are recording this argument, and I believe we're even live streaming it. As you come forward, please identify yourself and your client so that when we review the tapes, we'll be able to keep everybody straight. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the facts of the law. So when you begin your argument, go right to what you want us to be addressing. Counsel, you may begin.
Good morning. My name is Cameron Artigue. I'm here for the appellant, John A. Vanderwey. With the courts, unless the court knocks me off track, my plan is to talk first about the consistency of the general verdict and the special interrogatory, and talk second about the appellee's contention that this issue has been waived.
Could I just put a little introductory question before you now?
Absolutely, Judge.
But you talk about the special interrogatory. I have to admit that this special interrogatory threw me in this case, because it seems like there's a false dilemma presented in the theory of the case that both sides have embraced. And that is this a lease, or is this a certain type of contract with all the baggage that might carry from history with it? There seems to have been relatively little attention paid to the actual text of the contract. And so I'm uncertain of how the court got to the position that it thought that the question asked in the special interrogatory was even worth asking. So perhaps he could help you.
Judge, both sides have quoted paragraph 4 of the Cropper contract in full in their briefs. It is true that it's about 4 sentences long. There's a sentence and a half that really bears upon the issue that's been litigated here. And it says, in so many words, that John Vanderwey and FST Farms are going to split the income from growing alfalfa. That's all it says.
It also says cryptically that it's not a joint venture, even though it practically sings joint venture in choral form. But
not an issue in the case, though, Judge. Well, I mean, there's no allegation, no attempt to prove any sort of joint venture here. Judge Broadman, I'm sorry.
No, I agree with
you.
But the contract is understandably a little difficult to work through in this setting. I'm just unclear why a characterization of the contract is important, and why we don't simply turn to its text, read it, and apply it.
Well, I guess the way I would answer your question is, if it is a straight up split the profits, split the income contract, we have here the best point of comparison that you could possibly have, which is that ADOT takes half an alfalfa field. Alfalfa continues to be grown on the other half. So it's like a perfect science experiment. The result of the harvest on the undisturbed half is that each side makes $10,000 from growing alfalfa. You just don't see comparisons like that in real life. And if you are in the box that the remedies for the damages for breach of contract is that which would have put you in the position that full performance would have put you, they get $10,000. And so that's the sort of, if you look at this simply, that's what the plaintiff gets.
I guess
now let me answer your, well, I was about to.
Would I be wrong to look at it that way?
It would be correct to look at it that way, and it is necessary to look at it that way, the jury having rejected the plaintiff's contention that this is really a lease. And what the plaintiff alleged is, wait, we're not in that box. We're not in the damages to get us back to where performance would have put us box. We want a slice of the condemnation money that ADOT paid to the landowner. And so we have a lease, and that's what the opening brief goes into. A lease is an interest in real estate under property law. Judge Broadman says back in September, well, I think the big issue here is it a lease or is it a cropper's contract, which is not a lease.
And I guess my question is very narrow. Is it it seems to me the question, if anything, should be, is it a lease or is it a contract?
Well, leases.
Not is it a cropper's contract, which implies employment and all this business, but is it a lease or a contract? Seems like the right question to ask. The special interrogatories seem to come with more baggage.
Well, the judge wrote the special interrogatory at the plaintiff's behest. A lease is a species of contract, Judge Swan. I mean, so that's a false dichotomy. A lease is a contract which conveys an interest in real property. A cropper's contract is essentially an employment contract. You grow the crop, I'll pay you a share as your wages.
There's a third option, which is a contract that is neither an employment contract nor a lease.
A valid point of view, Judge, not one which was ever litigated. I mean, the parties and the judge agreed, the critical issue in this case, the pivotal issue, shall be framed in this single special interrogatory. That interrogatory was asked. My side won, the plaintiff lost, and that interrogatory answer, under the law, is superior to, is logically antecedent to the general verdict. And that's not like that's not an accident. The reason you ask juries special interrogatories, the reason you can ask them if you want to, is to constrain the wide discretion that they usually have under a general verdict. Because, in a general verdict, hey, juries can split the baby and do all sorts of things. You ask special interrogatories to delimit and guide and constrain. That's why you get to the different standard of review. Because if I was standing here on an appeal from a general verdict, it's way uphill for the appellant. If I'm standing here saying, hey, the general verdict doesn't logically follow from the interrogatory answer, de novo. Totally different standard of review. And so I agree with you, Judge Swan, that we could go back and do a woulda, shoulda, mighta, ask more interrogatories or less or different. I'm appealing from the way this case was litigated. And it was litigated as the plaintiff wants to grab on to some of the Arizona Department of Transportation proceeds because they too are a real estate owner. That's what gets their foot in the door. And the reason that they can't reach any share of that ADOT money as a cropper is because, A, the income that ADOT paid out, the dollars that ADOT paid, didn't go to my client and didn't go to FST. And try as you might, you can't split zero and come up with any number other than zero. The other reason that a cropper or an employee or someone who doesn't have a lease can't reach the ADOT money is because the law, the statute, the case law shows that ADOT pays, it only can pay, it only does pay for real property, fixtures and land. And that's all it pays for, that's all it ever has paid for. And that's why we had all this, the rending of garments over who owns the alfalfa stand and who owns the cutting, because they were trying to get an interest in real property. Now, the submission of the appellee on appeal, go ahead.
Items could represent costs, even if they don't represent a property interest, and those costs could be relevant in a damage calculation, even under your theory. Yes?
No, I mean, any costs go towards calculating the $10,000. We sold the alfalfa. If you net out the costs, each side makes $10,000. And no one is suggesting that any different amount of money would have been made farming the west half of the field where ADOT built the freeway.
Well, I'm sure Mr. Feltus is going to have something to say about this. But my question is, if you spend $100,000 and your expected gross is 110, that's a $10,000
Right.
profit. if somebody's halfway into the contract and they've been spending money in reliance on the contract, giving them $10,000 does not necessarily restore them to the position that they should be. There may also have to be some cost recovery associated with that.
No, it's netted out. It's Trial Exhibit 74, Judge. That nets off proceeds of alfalfa minus costs. That's what Trial Exhibit 74 shows. And it certainly doesn't get you to 207,000.
Well, I
You know,
understand. But as we talk about that calculation, proceeds minus cost equals profit, I agree with that. But in this case, where there were no proceeds, and there were probably some reduced costs, profit alone may not be the only data point you need to calculate proper contract damages.
Well, that's an argument they never made. I mean, I don't know if they have a different, their different damages calculation was give us half the money that ADOT paid to Rexco. They weren't saying it shouldn't be, it's not 10, it should be 20, or, you know, it was give us, I mean.
I just want to test this theory with both sides and see if I'm somehow misunderstanding the record.
I don't think you are. There is no theory here on which you can get to $207,000 had alfalfa been farmed. What the jury did here is if I may use the idiom, is split the baby. And they went in the jury room and said, well, we will reject the plaintiff's theory of the case and give the defense that, but we'll give the plaintiff a lot of the damages they're asking for.
So, counsel,
And you can't do that.
for my edification, we have a special interrogatory saying this is a contract. And I understand a lease is a contract, but this was a contract. Is there a statute or a case that sets damages for a, I guess we're calling it a cropper's contract at something different than any other contract?
No, the jury instruction that was given was straight out of the Raji, Judge Weinswag, that contract damages, the measure of damages for breach of contract under Arizona law is, you know, the cases that, there's no special measure of damages for cropper's contract. There was a Raji breach of contract instruction given.
And so what
without objection.
And the measure is what?
Is, and I'm paraphrasing here, but it's familiar stuff. The measure of damages is the amount of money that would put the plaintiff back in the position the plaintiff would have occupied in case of full performance.
And that's the singular issue, given the special interrogatory.
Yes. Well, the singular issue is that the factual finding that there is no real estate interest, that the ADOT payment can have no relevance here, because ADOT only pays for real estate. The ADOT doesn't pay employees when they lose their jobs, when, you know, there's a condemnation. That factual finding has no logical, probable, rational connection to a $207,000 number. They tried to split the baby, and they irreparably damaged the baby, if I may put it that way. I mean, you know,
does a jury have authority to depart from the accepted contract damages?
No, absolutely not. And they have no authority to enter a general verdict that doesn't follow from their own interrogatory answer. That's the error here. That's why the jury, I guess, thought that, you know, that they could do this. And there is a, you know, it's like if the jury finds in a special interrogatory plaintiff suffered no damages, but we're going to give him some money in a general verdict, it doesn't compute. And that's what happened here. And you can't just say, well, the jury has discretion, but they have a lot less discretion when they've answered the pivotal special interrogatory. And that's where we're at. I'm not going to talk about the waiver issue unless I get asked a question about it. In my reply brief, I marched through how the federal case law under Rule 49b3 is right on point, is controlling, makes sense, and says there's no waiver here because my client wasn't obligated to sort of anticipate an error and do something that is contrary to his own interests. Go ahead.
So, do both sides agree the damages are either $10,000 or $207,000?
Well, no, I mean, Mr. Felt, as Judge Swan said, will have his own argument, but the $10,000 number, it is an overstatement to say that that's stipulated, because it wasn't, but it was not disputed. I mean, it was conceded. Like I said, because for the first time in my career, you had this.
Was it conceded as a measure of damages, or was it conceded as a measure of what the lost profit?
It was the latter. It was conceded as the profit that was in fact realized by growing the alfalfa on the other half of the field. Thank you.
Was there a covenant of good faith and fair dealing claim?
Yes, my client prevailed, and the cross appeal was abandoned. So that is not an issue.
Thank you, counsel. Counsel?
May it please the court, Todd Feltus on behalf of the appellee FST Farms, Inc. To pick up on the implied covenant claim, I mean, in the record will show kind of how Judge Brodman handled it in connection with the jury instructions, but he merged it within the breach of contract count in which the jury found in my client's favor. So that was most definitely not ruled in favor of Mr. Vanderwey. Main headline here is the jury got this case right. I don't think either party liked the outcome. There was something for everyone in it, but the jury got it right. And what I mean by they got it right is that there was substantial evidence for the jury to conclude that FST was entitled to $207,214.20 under a croppers agreement arrangement. The jury answered that interrogatory as a croppers contract. The reason that we asked for this, and we asked for the special interrogatory, is, as Mr. Vanderwey's counsel argues, that you bring these things in to box the jury in. And had the jury answered that this was a lease, we would have had two ways to recover. We would have had.
It's an oddly shaped box, though. Why contract? Why croppers contract as opposed to just mere contract?
Well, I'd have to go back and.
Because croppers contract carries with it all of these implications of employment and that could really change the analysis, whereas this appears to be, to my eye, this appears to plainly be a joint venture with a disclaimer.
Yeah, no, I mean, I think that's probably a fair characterization. I don't have a good answer to your question on why. Okay. And the fact of the matter is that the jury made the conclusion that it did. And I think I think the verdict is still permissible, notwithstanding that conclusion.
So we would concede for a moment, then, for purposes of today, that the jury was right that it wasn't a lease, correct?
That's correct. We dropped our cross appeal on that issue.
Right, and we would concede. Well, and then you would say that even without a lease, there's some basis for a $200,000 recovery that does not depend on the negotiation history and the condemnation. Is that a fair statement? That's almost a fair statement, and I guess the negotiation history is I guess where I'd hesitate on that is on the last point. The negotiation history was relevant because that set what the crop loss proceeds were as part of the condemnation. The condemnation was part of the condemnation, but lacking a property interest, you still believe you can get to the condemnation proceeds? Through the contract, because $1 million of the condemnation proceeds was allocated towards the crop loss. This would have been the leaseholder's right. We had a contract with the leaseholder, John A. Vanderwey. Well, that number could have conceivably been $3 million, depending on how far you look out. Right, there are going to be crops coming for a long time if you're the owner of this land, but your client only has an interest for a finite period of time. I agree with you 100%. And the jury made we argued, and regardless whether this was a lease or a cropper's contract, that the crop loss period
I mean, alfalfa has a 4-year life. The parties conceded and stipulated that the life of this alfalfa crop expired at the end of 2016, same duration as our share crop agreement.
But might that not affect the value? I mean, if we assume for a moment a world in which your clients had a direct claim on the allocated crop value, if I'm a landowner, I'm going to tell ADOR my great-grandchildren are going to be enjoying alfalfa from this field, so you need to discount the present value a very long stream, which your client would have no claim on.
But that's not, I understand what you're saying, Your Honor, but that's not what I mean, that's just not what the trial record is. I mean, the trial record is that alfalfa was a crop of a particular duration. 4 years was the standard. That's what's in the record.
Well, I accept that, and what's probably not in the record is the internal formulas that the negotiators on the settlement used to arrive at that $1 million.
Exhibit 51 illustrates
Illustrates the methodology,
Right.
But I guess what I'm saying is because it was a settlement, and tell me if I'm wrong, but it seems that the parties had wide discretion to agree on a wide range of numbers that could have varied based primarily on the number of years in the future you're looking at.
That wasn't they could. I mean, I'd agree with that in principle, but I mean, again, that's not what happened. That's not what the evidence is.
Okay.
That's not what the evidence is in the record. I mean, I agree with you that Rexco, who basically acted as an agent of Mr. Vanderwey, and that was ruled as a matter of law in a Rule 50 motion.
Right.
So, I mean, they're kind of one and the same as it relates to the crop loss proceeds, which is what the leaseholder gets in the condemnation. So, certainly I agree with you. They could have agreed on anything, and I would argue that the agreement they did reach sets the basic definition of fair market value for what that crop loss is, because it's what a willing buyer was willing to pay a willing seller in this circumstance.
So we have a contract, and we have contract damages, which are to place the non-breaching party in the same position. Can you walk me through how you get from 10 to wherever the jury got, and annotate it, if you can, with citations maybe to the record, so I understand that there's a reasonable basis for the
Sure.
jury's path?
Sure, and your question gets to my whole outline for today. I mean, let's start with the first piece of it is the contractual entitlement. And Section 4 of the sharecrop agreement is, I mean, nobody's contended that this is an unambiguous contract that should be construed as a matter of law. So there was a dispute, and there was evidence in the record as to what Vanderwey's, shall be entitled to 1/2 of all crops produced. The evidence in that record was that it was broader than just the sale of actual crops. It also included, and the contract contemplates that FST is the one who will make the sale and then share the proceeds with Mr. Vanderwey. The evidence in the record was it was more was shared than just the mere sale of alfalfa or whatever crop was being farmed. If there were government subsidies, those got shared. If there's crop proceeds paid from crop insurance, that got shared. If there was an instance where Mr. Vanderwey actually sold the crop, he provided half those proceeds to FST
And I understand
Farms.
evidence in the record, but what about the ink in the contract? Does that say expressly that term that you're?
No, it does not. But based on that substantial evidence that was available to the jury could permissibly conclude that the parties intended on the crop proceeds in Section 4 to cover all income that derives from the sale of the crop. And again, there wasn't any kind of Rule 50 motion that was brought on this. This was the evidence in the record, and the jury could permissibly reach that conclusion. So that gets us...
Well, income to whom? I mean, isn't that the problem? Mr. Artigue's client didn't receive the income.
He did receive the income, and the record's pretty clear that Mr. Vanderwey willingly gave up the income that was his entitlement as the leaseholder from crop income that was produced on the property. And this would get to, at a minimum, breach of the implied covenant of good faith and fair dealing. And Mr. Vanderwey said, I don't want it, I'm going to give it to my kids. I mean, that's how the evidence shook out. I mean, moreover, they never made this argument. I mean, the first time they made this argument was in the reply brief. And certainly if this argument had been made at trial, it would have given the claim a little more jury appeal from our standpoint as to what they were up to. Because the conduct was, I mean, the records shows an underhanded series of conduct as it relates to how Rexco is negotiating with ADOT.
Chancellor, it may be that I didn't understand your answer to Judge Wansworth's question. What are the items that get you from the profit to the 207,000?
Well, no, and thank you for kind of getting me back on track on that. The second piece of that question is the damages. The damages are, I mean, what are the lost profits here? Well, the income that was derived from the crop wasn't the income we didn't receive had those acreage been farmed, but it was what ADOT actually paid. And the jury.
Well, but I don't understand what right FST under the contract would have a right to any of the condemnation proceeds.
They have a right to 1/2 of the income from the crop, the proceeds that come from the crops. $1,036,072 of this condemnation money was attributed to crop loss. So that's income from the crop.
They had a right to the value of the crops within the duration of the contract.
Well,
Does the record show somewhere that I've missed that anybody agreed that this $1 million represented the profit from a single crop?
No, it was a series of crops, and here's where we have there's conflicting evidence in the record, and there was substantial evidence for the jury to get where they went on this. From what we argued was that we're entitled to half the proceeds because the undisputed stipulated evidence was that the crop period ended at 2016, so whatever was paid would be paid out for crops that would necessarily coincide with the contract term. Mr. Vanderwey argued that no, look, there's only 6 months left because the condemnation was at the end of June or the 1st of July of 2016, so they get the last 6 months and they computed 30 months. So they came up with an alternative theory. I mean, Mr. Vanderwey.
But given the four-year cycle.
Right.
Why is 6 months versus 30 months the relevant calculation? Shouldn't it be one crop versus the next hypothetical crop?
Not alfalfa, and this is in the record too, that there's cuttings every 4 to 6 weeks that occurs. So that you're able to harvest this over and over and over again, and then at the end of the 4-year life cycle of it, it gets exhausted, and you need to replant something else.
At the end of the 4-year life cycle, though, it's going to take a while to recharge that payment cycle.
Well, right, and they're going to move. Well, and there isn't anything in the record that indicates anything other than a 4-year loss. And the trial testimony was that they'd go to soybeans or some other crop for a couple of years while the land recovered from the alfalfa. So there are what the jury agreed that FST was entitled to a share of the crop loss proceeds attributable to condemnation. They agreed with Mr. Vanderwey's argument that some of the crop loss proceeds were attributable to after 2016. There was conflicting evidence in the record as to whether it ended at the end of 2016, as I'd submit the stipulated facts in the joint pretrial statement say, or we have the 30 months that they argued, but there was also conflicting evidence with that. For example, John K. Vanderwey and Nick Vanderwey told the appraiser the crop was planted in 2013 instead of 2012. This moved the number back a year. When they did the appraisals, this isn't happening in real time, so mathematical precision's impossible.
Well, for sure. I understand the precision's impossible. I'm just getting back to the structure.
Sure.
Which still troubles me a bit. You're suggesting that there was some underhanded conduct because the money was given away to the kids. But the money was, Mr. Vanderwey was never a party to this condemnation. Right?
He should have been. He was a leaseholder.
Well, that's a great argument to make to the state, but how can you say that somebody who was never served, to be effectively a defendant, has done something wrong by not getting in the game?
Because the trial record's clear from Mr. Vanderwey's testimony that he agreed that the kids could have the money as it related to the leasehold interest. So, I mean, he essentially gave away the money that was his so that it would not be shared with FST.
But your client didn't intervene either to try and ensure that the alignment of parties in the condemnation action fit your model.
Well, I mean,
Right, because the time to make that argument is, hey, Vanderwey's got a whole windfall coming his way. State, you've got to make sure that he's properly joined so he can get the windfall so we can get our piece.
well, there was a disclaimer that was done, but it confused. The FST principals had an interest in land next door and received condemnation proceeds from that. ADOT had named the wrong party. I think the assumption was that it would get corrected and never did. We never found, the record is that FST never found out about the condemnation until after the ship sailed. So, I mean, they didn't understand what the process was. And again, it's their contracting party who had an obligation to split these proceeds who left them in the dark on this. And I mean, again, I guess to get back to the imprecise but supported by the evidence calculation of damages is that the jury could have concluded that there was a sliding scale between the $103,000 that Mr. Vanderwey argued to the jury as an alternative calculation that fits in to the theory that we're saying supports the jury verdict. And there was a sliding scale between 24 months past the contract term of 2016 and 0, which is what we argued, and the jury came somewhere in the middle. And I mean, can you go back through arithmetically and say that it was a precise number? No, but Mr. Vanderwey's number that was his alternative theory to the jury, he argued that the jury could permissibly award a portion of the crop loss proceeds of $103,000. But even that number would be subject to imprecision because the final appraisal was done 8.5 months before, not 6. It didn't take into account an appropriate discount rate.
Okay, so how do you then deal with Mr. Artigue's comment that the ruling on the special interrogatory is just inconsistent with the calculations of the report?
My argument is that it's not.
Well, I'm not surprised.
Yeah.
Help me out.
Okay, sure. I mean, I think you go right to the contract. The jury concluded, supported by substantial evidence, that the crop proceeds in Section 4 was broad enough to include crop loss attributable to condemnation. That money belonged to the leaseholder. That's the evidence in the record. And that money was not, and that leaseholder was John Vanderwey. It was income derived from producing crops on the property, and that money was not split. I mean, that's
not paid, but okay.
That's,
so basically, your theory hangs together as long as we honor the assumption that Mr. Vanderwey could or should have received $1 million.
well, that's ultimately what the jury concluded.
Yeah, but that's in a different case to which Mr. Vanderwey is not a party, so it gets more complicated.
Well, I mean, the record in this case in the trial testimony was that Mr. Vanderwey knew it was his money. He knew that the crop loss was attributable to the leasehold interest, and he agreed that that money could go to Rexco, the property owner. And Tom Flynn, who testified at trial, said that the crop loss money went to the leasehold interest. So,
yes, I understand that factually, that's your take on the record. But legally, to get to the result you want, we have to indulge the assumption that what everybody was saying and feeling and believing about those proceeds was actually true as a matter of fact.
well, I think those funds belong to Mr. Vanderwey. They came from the.
I'd love to be getting funds from cases to which I'm not a party, but
Well,
I'm not aware of much precedent for that.
Well, but it's not coming from the case. It's coming from a negotiated it came from a negotiated settlement with ADOT that settled all of the various landowner claims, I should say property.
It didn't settle. Mr. Vanderwey did not negotiate that settlement on behalf of himself because he had no standing to, given the alignment of pleadings in the case.
He absolutely had standing in the negotiation, and this was, he had a property interest.
Sort of
It's the
a
leaseholder.
Pre-filing settlement?
What's that?
Like a pre-filing settlement notion, something like?
Yeah,
he's
you know,
obviously a party that just go ahead and negotiate, that kind of thing?
Well, again, ADOT was given the various appraisals that were given said that this property was owner operated. It wasn't. So, I mean, ADOT was working under a false premise. And yeah, they had to get the leaseholder interest resolved. And yeah, it's a factual issue. I think the jury could have reached any number of conclusions here. And the conclusion that they reached was that there was income that was produced as a result of the crops, that those proceeds should be split 50-50, and there was a portion of that crop loss that extended beyond the 2016 term of the contract. And within a term that was supported by the evidence. So there may be things that we don't like about the outcome of this jury verdict. There may be other correct answers, but this jury reached a permissible verdict that was fully supported by the substantial evidence, imperfect as it may be.
So ADOT paid more for the crop loss than FST and Vanderwey would have gotten from operating that part of the crop and earning profits from that.
That's what the record, that would be consistent with the record. But again, I mean, ADOT was essentially the buyer of the counterfactual crops that were never produced, just like the $10,000 lost profit number is a counterfactual.
Okay. Thank you, counsel. Counsel?
Thank you. I'm going to clarify how this worked as between ADOT and Rexco. The ADOT representative testified at trial, under oath obviously, that the payment was made to Rexco purely to Rexco, for Rexco's land, and that there was no obligation on Rexco's part to sort of send it along to anyone else downstream. There has been, Mr. Feltus argues that John Vanderwey, my client, gave the money to his kids. This is a very inaccurate and unfair insinuation. Mr. Vanderwey's testimony was he didn't get anything. He was not a party to the Rexco condemnation. I guess he could have intervened, just like FST could have intervened. But in point of fact, ADOT sat across the table with Rexco, who was represented by Marty Aronson, and they settled the lawsuit. Now, the Exhibit 51, the ADOT internal appraisal, has the word income in it. And it's there because they were using an income method of valuation. This is what appraisers do. You look at the apartment rents, the commercial rents, the crop yields, and you say, yeah, we're taking not just the land, we're taking the alfalfa plants, which are fixtures, and they're probably good for another 4 years, so let's have an income component to our valuation of Rexco's land. That's not a payment for, people down the stream. If you condemn an apartment complex, you may value it based on the income that the rents generate. That doesn't mean the money goes to the tenants. It doesn't go to the people who work at the apartment complex. And so when we hear these references to the crop loss payment, it makes it sound like it's some sort of insurance payment to cover the losses of the cropper and my client. No, it's just a payment for the land and the fixtures. Judge Swan, go ahead.
Any interest Vanderwey may have had with the condemnation procedures between him and Rexco, correct?
Precisely. Yes. That is exactly right, Judge. Yeah, and if he's got a theoretical interest, that's as between him and Rexco. I'm just repeating what you said, Judge Howe. And there's nothing underhanded here. I mean, it is, if Rexco negotiated well with ADOT, bully for them. That's between ADOT and maybe that's great for Rexco, maybe it's not great for ADOT. Neither of them is a party here. It's just like outside this lawsuit. This is a contract between John Vanderwey and the FST Farms, which is a cropper contract. Judge Swan, your initial question is why isn't it a joint venture? And it wasn't litigated that way. And I guess I just looked at the exhibit when I was seated, and it does say sharecrop agreement in caps at the top of the first page. So that's the way it was framed and litigated. That's the finding.
If it had said deed on top, would you have conceded that it conveyed an interest in land?
No, we would have a very different case, Judge.
I thought
Yeah, we would have a very different case. But we have a finding here that this is a cropper contract, ergo no interest in land, ergo no way to grab on to ADOT money, which is as a matter of law only for land. And as a matter of fact, because that's what ADOT testified, this is just for Rexco's interest. Let me just close with this. This is a very factual argument to have in this courtroom. It normally doesn't get this kind of deep into the weeds of what the jury was thinking and doing. Normally that's bad for the appellant. In this context, I think it's good for the appellant because what's going on is a struggle to understand how in the hell the jury how you could reconcile the special interrogatory finding with a verdict. And the answer is you can't. They split the baby, and maybe you could do that in a general verdict context, but the point of the special interrogatory is to propel them to a result that is consistent with their factual finding, and that did not happen here. Thank you.
Counsel. We appreciate your arguments today, and we'll take this matter under advisement and issue a decision in due course. We stand adjourned.